I'm Lisa Swaminathan. This is Karen Lindell. We're from Juvenile Law Center. We are not from Florida. We work for a national organization that works on the national level in the child welfare system. And so we do a lot of trainings and policy advocacy and litigation around transition planning and courtroom strategies for system-involved youth. So we're here today to talk about national transition strategies. We're going to be talking about some strategies that you can employ in the courtroom that really focuses on the federal law. And so just we're not Florida attorneys, so we won't be talking about really much law that is specific to Florida. And we're going to start out today. Well, actually, before that, you know who we are, but we don't know who's in the room. So could I just get a show of hands? Who in the room is an attorney? Oh, so pretty much everyone. That's good, because we're talking about the courtroom. And who is a child advocate attorney? Okay. Attorney ad litem? Representing kids. Yes. Okay. Right. So anybody representing kids is their attorney. Is that everybody in the room, or? Okay. Either. Just anybody who's represent. Okay. So okay.
How would you represent the agency in an independency proceeding?
Okay.
Anybody or in a delinquency proceeding? Okay.
Okay.
How many represent? Or do you have any parent advocates? Okay.
Okay.
And then you represent the child either in an expressed interest capacity or in a best interest capacity. All right. Thank
Okay.
you.
And any non-attorneys? So what we're going to be doing today is we're going to do a brief background about transition planning specifically for youth with disabilities. We're going to talk about the federal laws that kind of serve to form the basis of the tools, kind of the toolkit that you can use in the courtroom. And then we have some sample activities that we're going to ask you guys to kind of come up with a courtroom strategy based on the challenges that you see in those individual cases. And then we're going to talk and summarize about kind of what you guys found in your cases and some strategies that you guys can employ going forward in the courtroom. So with that, I'm going to hand it over to Karen, who's going to give you some more background.
Thanks, Lisa. So as Lisa mentioned, my name's Karen Lindell, and I'm an attorney at Juvenile Law Center as well. And as Lisa mentioned, we're in Philadelphia. We were based in Philadelphia, and so this is a trip down to Florida for us, which has been quite fun to get to be in the sunny South for a little bit. So I know that you guys are at the tail end of a conference here, and so we're not going to dwell too much on some background. I think probably that all of the awesome presentations up until now have given you some of that. But we want to spend a few minutes orienting you kind of to what we're going to focus on today, which is older youth with disabilities who are approaching transition out of the child welfare system. So this might be kind of a subset of your clients. It might be a lot of your clients. So can I just see again, sort of just show of hands, how many of you do you feel that, about less than a quarter of, or less than 10% of your clients, let me say, are 14 or older? All right, what about between 10 and 25%? 25 and 50? Okay, so some people, and then more than 50%? All right. So it's, as we know, it's definitely a large chunk of kids in the child welfare system. As you can see, that pie chart shows the national statistics of 24% of youth who enter care at age 14 or older. So obviously there's a larger percentage who might have entered at a younger age who are now approaching transition out of care. And the numbers for aging out nationally are more than 20,000 kids who aged out in 2015, and it's sort of a similar number to years around that time period. And in Florida, the figures that I found sort of suggested that right around 1,000 kids, a little fewer than that, age out each year. So it's certainly a big chunk of kids. We also know, sorry, we're supposed to have up here already, that youth with disabilities are overrepresented in foster care. These numbers might be kind of familiar to you. They might not be. 60% roughly of kids in the child welfare system receive special education. There might be more that are eligible that haven't been identified. Studies have shown that 90% have at least one health problem, and a majority have 2 or more health problems. And as I'm sure many of you have seen from your practice, a large majority have some sort of mental health or behavioral health diagnosis. I'm not going to dwell on these sort of background slides. This shows, they should be in your app, so if you want to sort of see in more depth. But this just shows that particularly in the mental health, behavioral health diagnoses, the difference between the foster care population prevalence rates, or foster care alumni, and the general population. And then a thing that we always have to keep in the back of our mind as child advocates are the effects of trauma. Having a trauma history does not necessarily mean that you have a disability, that you should be identified or labeled as a behavioral health or having a behavioral health or mental health problem. But it's obviously something that can produce those effects and something we always want to be keeping in mind as child advocates. So I just want to spend a moment before we delve into some of the legal rights that Lisa mentioned, talking about why we're even having a session on transition issues for older youth with disabilities. And some of this might seem a little bit obvious, but let's just sort of think in that direction. You know, what makes transition to adulthood particularly challenging for your clients who are older, who might be aging out of the system, and who have some sort of physical, mental, behavioral health need? Anyone want to volunteer something? Doesn't have to be mind-blowing, revolutionary, just some sort of basic things that are what we're trying to really target as child advocates. Yes?
Do you have systems like Social Security that, you know, are going to come into play when they turn 18 and there's a redetermination, and at the same time they might be leaving care and their issues just with who is going to be watching out after they exit?
Yes, definitely. So I'm just going to repeat a little bit because we've been told we're being recorded, and so that will help the recording. So the multiple service systems involved, you mentioned in particular with SSI, with Social Security, having the redetermination process at age 18, and just identifying who the people are, you know, as you're transitioning between service systems and as you age out of care. Absolutely. Yes?
They have a lack of connection with adults in their lives, that when they age out of foster care, they, other than the people they've met within the system, they don't have any connection.
So lack of supportive connections, absolutely. There's studies that show that having a supportive adult in your life is the strongest indicator of whether you'll have a successful transition to adulthood. And as we'll talk about more, these young people have particular challenges with that sometimes, especially when they're in institutional placements. Any other things you want to mention before I move on? Yes, ma'am.
Transportation, placement, mental health issues and services that they've been receiving, how to transition those services, like I said, supportive adults or support system.
Mm-hmm. A lot of stuff, yeah. So transportation, placement, jobs, absolutely. Say that one more time. Nutrition. Oh, interesting. You want to say a little bit more about what you're thinking?
I'm just thinking they don't even know how to cook for themselves.
Right. So, and that's another thing we'll talk about is some of the normalcy principles, the independent living skills. Sometimes when we have kids with special healthcare needs, understandably their disability concerns are high up there on the list and some other things might not be discussed, but yet these kids end up aging out with the same, you know, needing to have the same skill set that a lot of their peers do. So absolutely. All right, so those are absolutely things that we've encountered. They can be really daunting barriers. You know, you hit on so many of the sort of issues of multiple service systems. These are a few things that unfortunately studies have shown that youth with disabilities who age out of care have lower levels of educational attainment in adulthood than their peers, and this is within their child welfare involved peers. So we're looking at populations of kids who have aged out of care, kids with disabilities have all of these negative outcomes at higher rates than their peers, unfortunately. But studies have also shown that transition services do make a difference in things both ranging from their employment levels later and their educational levels later to also their emotional well-being and their sort of self-esteem. So we know that we can make a difference in this area. And again, this is another sort of background graphic. I'm not going to spend a ton of time on this. You're going to hear a lot of themes around what it means to sort of successfully transition. But I want to just plant the mindset that what we're talking about is a process that is not something that can begin just 90 days before a child ages out of care. We're talking about something that sort of has to start with getting a good understanding of their medical needs from as soon as they're entering the child welfare system, having appropriate supportive services in place during their duration of time in care, including high quality education services. And then, of course, you do need strong transition planning. You need to get connected to the adult serving systems and have those things in place if you're aging out or if you're leaving before aging out, and having post-discharge services. But it's really, we're talking about a process. These are all overlapping things, and they take a lot of time. So that's sort of what we mean by transition. So with that very basic background, I'm going to hand it back over to Lisa. We're going to be giving you guys sort of a very quick primer on a bunch of the different federal laws that can touch on transition advocacy strategies. We appreciate it's going to be kind of a 30,000-foot view. We're going to go kind of quickly through some of it. That's with the interest of spending more time in the activity that we have for you guys, which I really think will help unpack how we actually translate some of these legal principles into courtroom advocacy in the context of an actual client. And Lisa, what's that? Oh, that's true. We can build. Okay. Yeah,
So we're
going to tag team here. So
we framed what we're thinking about today as rights of youth who are in care. So I'm going to talk to you a little bit about one of those rights, some of the challenges that we have in ensuring those rights for youth with disabilities, and then briefly kind of some of the tools that we have to help kids realize those rights. So the first is the right to effective screening, assessment, and treatment. And we know that under fostering connections, states are required to develop a plan for ongoing oversight and coordination of healthcare services for any child in a placement. And the plan has to ensure a strategy to identify and respond to those needs. So in other words, if you're in care, your health should be taken care of. But we know that doesn't happen. We know that even when kids are assessed, we have a lot of problems effectively treating youth with disabilities who are in care. Some of those problems are under, over, and misdiagnosis. When you don't have the appropriate diagnosis, it's impossible to provide the appropriate treatment for a child. And unfortunately, when youth are under, over, or misdiagnosed, that leads to frequently labeling them. Kids who aren't responding to treatment are sometimes labeled defiant, uncooperative with their treatment, when really the problem is a mismatch between what the services we're giving them and what they actually need. And then similarly, this one-size-fits-all treatment. It's really difficult, especially for kids who are in care, to advocate for individualized services and treatments. And so frequently, it's easiest to just do what we've done with every other child. And finally, over-reliance on group settings, and this kind of compounds all of those other problems that when kids are in group settings and don't have a dedicated parent or parent-like figure looking out for their health needs, it's very easy to under, over, or misdiagnose them or not readily identify that the services they're getting aren't meeting their needs. In the federal law, there is an assurance for at least a tool to pay for assessment, screening, and treatment for youth with disabilities, and that's the EPSDT promise under Medicaid. And that is early periodic screening, diagnostic treatment. So what that means, it's an ongoing continuum of screening, assessing, and treating youth who are entitled to Medicaid. And it means that youth are screened and assessed, so their needs are identified and evaluated. And then there's the promise that the treatment should be fitting of their individualized needs. This continues until age 21, and it, under Medicaid, pays for everything that kids need. And there's a wide range of surveillance, screening, and treatments that are covered, but essentially it should be everything.
And notably, although, as I think you guys have talked about in some other presentations, children can stay on Medicaid until 26 if they were in the foster care system at age 18. The EPSDT only is up until age 21. It's a 21 and under benefit. So it is something that changes for all youth, regardless of whether their insurance coverage actually changes when they're aging out. And the second right we're going to feature is the right to an appropriate placement. And this comes from a couple different federal provisions, actually. So first, as you all know, the federal child welfare law requires that all children in care, regardless of their disability status, be served in the least restrictive, most family-like setting appropriate to their needs. And so this is obviously the key place that we come back to if you're in a position of trying to argue for a more family-based, smaller setting as opposed to an institutionalized placement, is that they have a right to that under federal child welfare law. Kids with disabilities also have it under the Americans with Disabilities Act, or the ADA, that there's also, that it's considered to be a form of disability discrimination to provide services to any individual, child or adult, in a setting that is more restrictive than necessary to meet their needs. This is the sort of key Supreme Court case you may have heard in this area is the Olmstead decision. It did not involve kids in particular, but it's certainly applicable to children as well. And it's another sort of legal hook for arguing that children have a right to a family-based placement. Now, of course, that doesn't necessarily mean that we see that in all cases, and we're also not necessarily saying that all institutional settings at all times are inappropriate for kids. I know this is a very complex issue. There's certainly a place for meeting appropriate treatment needs, but what we're sort of, what our kind of take on this is that we should never consider institutional placements to be placement. They should be for treatment. There should be a reason that someone's going in for a particular regimen that's individualized, that meets their needs, and can be demonstrated as such. And yet we see, certainly in Pennsylvania, and I'd be certainly interested to hear your experiences as well, that many kids with disabilities disproportionately end up in group home or congregate care settings for much more prolonged periods of time. And there is sometimes confusion over whether it's a placement or a treatment, and exactly why is it that the young person might be spending time there. But of course, even when we're in sort of making our ideal legal arguments before the court, there are real funding concerns, and this is definitely an issue in Pennsylvania. We haven't had an increase in our rate for medical foster families since 1994. It can make it really challenging to find providers for that, and so it's sort of a constant struggle to find medically appropriate family-based placements for young people. But yet, as you've I think heard in other presentations during this conference, it's something that kids need developmentally to be able to be with a family and have those supportive connections. So how can we achieve that? So first thing is to remember that courts do have broad dispositional authority to identify what's in the child's best interest. And so, that some of the funding considerations and things might be able to be remedied through a court order if you're able to really make a compelling case that it's in the child's best interest. And then the ADA, this is another place where you can think of that legal hook specifically, because public entities are required to administer services in the most integrated setting. That could include, things like getting accommodations in a foster home or something. Maybe you need a wheelchair ramp. Maybe you need additional training for the foster parent to be able to know how to administer a particular medication or provide a particular service. That might be an accommodation you could argue for using the Americans with Disabilities Act. So just keep that in mind as a legal hook. And we'll see how that plays out a little bit in some of the case examples later.
So youth in care, or any youth who's involved in the child welfare system, has a right to permanency. And it's important to think of permanency as a different question than placement. Kids can be in group care, can be in foster care, and it's not predictive of what their permanency goal should be. And what that right entails is, first, the right to stay at home. So agencies have an obligation in the first place to prevent removal. Second, once kids are removed, to return them home. And then many courts will recognize a right to achieve another permanency plan. Well, that's not technically what the law says. Many states interpret the agency's requirement to make reasonable efforts to return a child home to be reasonable efforts to achieve whatever permanency goal is part of the child's permanency plan. And certainly if the goal is adoption, the agency is required to document efforts showing that they're moving towards that goal. And unfortunately, like so many other rights that are important in helping youth become successful adults, there are a lot of challenges that are unique to children with disabilities. The first is in terms of removal. Sometimes a child's disability can be the barrier to reunification, or can create a problem that the family is unable to deal with and is actually what is leading to their placement in the first place. And the services that families require to be able to adequately care for a child with disabilities can be more costly, can be more complicated, and it can be difficult for agencies to communicate effectively with families, to identify what the needs are, or to implement changes even once those needs are identified. There's also this idea that youth with disabilities are unadoptable. They're less desirable because they require more work once they're in your home. And frequently, without consulting with a child, their goal is not, there's not serious consideration that they can achieve permanency with an adoptive family. And also, what I mentioned earlier, just confusing placement with permanency. If an agency is unable to find an appropriate foster home, then sometimes adoption or other family-like permanency options are taken off the table early on.
And just I'd say the flip side of that can be true too sometimes, where, you know, a child's permanency goal might be APLA and might maybe be one of those cases that's what the child really wants, and it can be in their best interest, but that doesn't necessarily mean that we lose all focus on permanency in the form of supportive relationships and, you know, who is going to be that child's support network, and thinking sort of more broadly about what does it mean. You know, every individual needs a support network and needs a sense of permanency and family, and that even if we have someone who's going to be aging out, we shouldn't lose touch with focusing on those relationships.
Now, luckily, the law requires that the permanency plan is subject to judicial review before it's finalized. So it should never be the case that the agency or anybody just decides unilaterally what the permanency plan is without any chance for oversight. And judicial oversight of the permanency plan can be an extremely powerful tool to considering what's appropriate for this specific child. The federal law also strongly disfavors APLA, and here we've said that it's only acceptable if compelling reasons rule out other permanency plans, but in addition to that, the agency has to show that it's made intensive, ongoing, unsuccessful efforts to achieve another permanency plan. So that's a very high standard. It has to be the best permanency plan, and for older youth, the court has to consult with the child about his or her desired permanency outcome before it orders APLA as the appropriate permanency plan. So again, we're talking about judicial oversight here, but the law really disfavors an outcome that doesn't end up with a youth in a family-like environment.
All right, so then, again, we're going quick here and we know it, but we'll talk about all these in more depth in a few minutes. But the next right that could be a good legal hook is the right to access developmentally or age or developmentally appropriate activities. This is kind of a bit of a new one potentially to people. This comes from the Strengthening Families Act passed in 2014. And again, it's not a disability-specific provision. All youth are entitled to participate in activities that promote normalcy. And the sort of concept of normalcy includes the idea that we want kids in care to be having the same experiences that their kids, that their peers outside of the foster care system also have. So sports, participation in sports teams, having sleepovers, being able to go on field trips without having to go seek a court order. These are all things that are a really key part of normal adolescent development, and that's no less true for individuals with disabilities. And there's a part of the statute that you guys have maybe heard about in other contexts, the reasonable and prudent parent standard. This is how we, sort of the way that this law is effectuated is by allowing whoever's been designated as the person, it's usually the foster parent, but in a group home setting, there would have to be an individual identified at the placement to exercise the reasonable and prudent parent standard. And what that does is allow them to make any decisions that a normal, reasonable, and prudent parent would make under those circumstances without being subject to liability if any sort of risk to harm or injury resulted from that. And normalcy must be addressed in the case plan and at hearings. So there's another sort of legal or courtroom advocacy strategy that can come from this. So if you find that you're having a transportation barrier, for example, like you've got a client who's in a group home setting who really wants to be able to go spend weekends with ex-family member or friend, or sort of be able to participate in the like church group that they were in before they entered the group care setting, and there's a transportation barrier to that, you can argue that that's a developmentally appropriate activity. It's something the young person has a right to participate in, and transportation might be a necessary part of that. We know that this, although this is a provision that applies to everybody, youth with disabilities do have some particular challenges getting the full benefit of this legal protection. And I mentioned transportation just a moment ago. There's also, I've found in my work a lot that there's sometimes a presumption that this isn't something that youth with disabilities could benefit from to the same degree as their peers, which is something that we just have to sort of challenge at any point that you encounter it. There are sort of access issues beyond just transportation. There might be accommodations that are necessary to help access age or developmentally appropriate activities for young people with disabilities. And then there's, of course, just our basic concern about risk and safety, which is incredibly understandable, but has to be balanced with the notion of sort of more general well-being and the fact that we know that in order to develop supportive relationships, in order to develop independent living skills, in order to develop the skill set to be a thriving adult in the community, you have to sort of have this type of exposure and experience while you're still in care. And so balancing that against our understandable concern for risk and safety. So again, I'm going to keep turning back to my friend of the ADA here, and the Rehabilitation Act is the other big federal disability protection statute. Between the two of those statutes, it kind of covers all agencies that provide services. You know, it may be, the Rehabilitation Act is for federally funded services. The ADA covers a whole host of different things and is probably more often what would be applicable here, but not always. But both of them, they bar disability discrimination very broadly, and disability is defined very broadly. And so they can be legal hooks to ensure that if you find that, you know, all of the kids that you have that are in this group home because of a disability are not getting the same child welfare services that their peers are, including things like permanency services, that could be a form of disability discrimination that's actionable under the ADA. And you guys in Florida have actually a really good normalcy statute on your books. You know, all states have been working across the country to be implementing the federal provision. Just want to highlight here, obviously this is a very text-heavy slide, but that agencies are required to verify that private agencies are providing out-of-home services to dependent, or that are providing services to out-of-home services, have policies consistent with the normalcy provisions that promote and protect the ability of dependent children to participate in a whole host of activities.
Youth who are entitled to special education are also entitled to a free and appropriate public education. Now, the challenges in achieving that are true for all youth with disabilities, but specifically for youth who are in care, the ability to access a quality education faces additional obstacles, the first of which has to do with their placements. Frequent changes to placement often means frequent changes to schooling, and that is not only disruptive to what's happening in the classroom on an everyday basis, it can also lead to delayed graduation, frequent reassessments, or inappropriate education while reassessments are being done because records don't transfer easily, credit transfer problems, again, because records aren't transferring quickly between schools. When youth with disabilities are placed in group settings, sometimes that also carries with it the requirement that they attend an on-ground school, and sometimes the education that they receive in an on-ground school is subpar, and it's certainly not out in the community. And finally, the IDEA, the federal law that entitles youth to a free and appropriate public education, really contemplates an advocate who's in the room with the child when it comes to coming up with an education plan. And kids who are in care frequently don't have that person. Their parent might not be involved, and it can be hard to identify somebody who really can invest the time and knows the child well enough to advocate for an appropriate education plan. On the child welfare side, the tool for kind of combating some of these problems is ESSA, and that is a law that applies for all youth who are in the child welfare system, and it entitles youth to, number one, remain in the same school even when their placement changes. And that's a really important right, and it is tempered only by the child's best interest. So if it is not in the child's best interest to remain in their regular school, then they can transfer, but only in that case. It also, ESSA also provides a mechanism. It's not the strongest mechanism, but a mechanism for funding transportation. Youth are entitled to transportation so that they can continue to attend the same school, and that is generally paid for either by the Child Welfare Agency or the State Education Agency, or a combination of the two. It also requires that every state education have a point of contact for child welfare services, and that means there's somebody who is in the school district who's responsible for working with the Child Welfare Agency to make sure that kids remain in the same school, that transportation is worked out, and also, if kids don't remain in the same school, that their records are transferred quickly. Under the IDEA, youth with special education needs are entitled to transition planning beginning at age 16. This is a really important right because it complements the transition planning that we're already doing on the child welfare side. And it requires that transition planning focus on educational, employment, and independent living skills. And some of the these are all things that we should be thinking about as we're coming up with a transition plan for youth in the child welfare system, but there may be services and extra supports that we can offer to youth if we really coordinate what's going on the education side of things and the child welfare side of things. And in order to ensure that this planning process really does benefit the kids, family courts are empowered to appoint educational decision makers for children. And that's important because this idea of an advocate in the room, when there's no one there, we see that the IEPs for kids are really not as thorough or as effective as they should be. And so family courts have the authority to make sure that there is somebody in the room, and an obligation under the IDA to make sure that there is somebody there who can advocate for the child.
Can I just ask the question, since I know in Pennsylvania we have a lot of trouble coordinating the child welfare transition planning processes and legal requirements, which I'll talk about in a minute, with the IDEA's transition planning requirements. They're similar domains, they're similar legal requirements, they often apply to the same groups of kids. Does anyone have an experience? Have you ever worked in a way that that has those two things be in alignment, or those planning processes happen simultaneously? Is that something that people feel is a problem here? Is that I'm seeing a nod or two, several nods. Okay, yeah, no, it's a real challenge. Sort of the multiple service systems can be a real benefit. The IDEA, through its requirements, places a responsibility on the school district to provide a whole host of very robust services. And if you look at some of the transition plans that are in people's IEPs who have strong disability advocates or just really strong parent advocates, they can be really remarkable and include a whole host of services that are paid for in the school by the school district. And I don't think I've ever seen one for a kid in care that is sort of comparable without sort of significant education law involvement. So it's a missed opportunity, I think, a lot of times. All right. Oh, sure, yeah. All right, so moving on to the right to transition planning, which is a nice little segue there. So this, again, comes from federal law. The Fostering Connections Act requires that the Child Welfare Agency assist the child in developing a transition plan. Unfortunately, the federal law only has this requirement come in at 90 days before the child ages out of care. So when 90 days from anticipated discharge, the Child Welfare Agency must help the child develop a transition plan. Now, is that enough time for anyone to figure out how they're going to support themselves and where they're going to live and how they're going to know how to cook dinner the next night? No, that's absolutely not enough time. And so but we can still use the Fostering Connections Act's requirement to make transition planning part of court hearings from a long time before that. So if you sort of make the argument that we've got to be planning because we need to have a transition plan at 90 days before they're going to leave, and so we need to be thinking about all of these domains way ahead of time, and that we've got to do it in the way that the Fostering Connections Act contemplates, which is personalized at the direction of the child. That's something that you can sort of, we say it really needs to begin at age 14, and the Strengthening Families Act actually does provide some support for that. It requires that transition services be discussed at permanency hearings beginning at age 14. And so you can sort of say, look, we've got to be thinking about transition services for the kid. Let's think about them in the same domains that we're going to need to have in place when they're actually leaving. And so what I would recommend is sort of having each of these things: housing, health insurance, education, mentorship opportunities, workforce and employment services, be part of all case planning meetings beginning, when the young person is 14 or 16, and sort of from then on up, so that by the time you're at that 90-day mark, you actually have a meaningful plan, a plan A, a plan B, you're ready for contingencies, and use the Fostering Connections Act to get there. Of course, we've got challenges specific for kids with disabilities in this area too. One really big one is the fact that these are a higher needs group of individuals that are going to often require services through adult serving systems, which means, as people mentioned earlier, we've got to have systems communicating with each other. We have to know who to call at the at the Social Security office. We have to know how to get them connected to Medicaid waivers. There's a whole array of very complex systems that it's hard for the child serving systems to be familiar with, and that there's just delays, there's gaps in services, and for kids in child welfare, these things can be devastating. I worked with a young woman who was like a total success story until, of course, things went awry, where we had gotten her lined up. She was found eligible for SSI. She'd found an apartment. She was ready to move in. Her group home provider had found funds to furnish the apartment. And then there was a 30-day delay in getting the Social Security payments actually flowing into her account. And her landlord was not going to be able to tolerate 30 days without a rent payment. And she ended up finding funds from another source, but she was facing eviction before she'd even stepped out of the door. And so those kind of things all are another way to pitch the fact that you need to plan really early, because these kids just don't have the luxury of having gaps in benefits even when they're entitled to services. So I've mentioned several of these things already. Transition planning, setting the stage for effective advocacy, using that legal hook to say we've got to be talking about all of these things for a long time out. And then, of course, to say that we're going to have a transition plan in place, looking at that kind of thing at 14 or 16, doesn't mean that it's going to look the same as when you're planning for a 21-year-old, right? Like, if you ask a 14-year-old what career they might envision when they're aging out of care, when they're leaving the child welfare system, that's going to be something a lot more abstract than for a 14-year-old than for a 20 or a 21-year-old. The point is, it's a process. By asking them at 14, by working through it again at 15, by continuing, on into adulthood, by the time they get to 21, it's not the first time they've had that question asked. And so you're going to see progressively more concrete goals, progressively more specific support systems, and things will look different as time progresses. One key legal thing argument that we have found successful in Pennsylvania is arguing that a case can't be closed if there's not a good discharge plan in place, that there's an obligation of the child welfare system to have a transition plan, and if that's not been done, that you can't close a case where there's an inadequate plan. And that has been a successful pitch to judges many times in Philadelphia, even though there's sort of arguably lack of jurisdiction sometimes after that.
And outside of Pennsylvania as well.
Yeah, it's not just in Pennsylvania, yeah. And that brings me actually to extended foster care, which is another key legal protection in this area. And it's wonderful that Florida has extended care and that there's ability to re-enter. Your statute is actually one of my favorite because it has this provision that allows individuals with disabilities to remain in care until 22. And so you don't have the same sort of limit of court jurisdiction at 21, so that when you have somebody who might not yet have been connected to intellectual disability services or might still need SSI to be in place, that you have a little bit more of a cushion. Now, of course, what we don't want to have happen is that just push things back a year, right? You've got to use that period of time to get services in place, to get competencies developed and things like that. But it does give you that additional time, which can be really valuable. And this slide just has the requirements, which mirror the ones in the federal statute for what criteria you have to fulfill to be in extended foster care, and they're quite broad. Being in a secondary education or post-secondary program, participating in a program designed to remove barriers to employment, being employed for 80 hours a month, or being unable to participate in these activities due to a disability. So there is this sort of catch-all at the end for clients who have special needs that might limit their ability to satisfy these other criteria. We have been successful in arguing that that last one doesn't have to be a permanent inability. So if you have someone who's in a mental health crisis that's preventing them from being able to remain enrolled in an education program, or that's making it challenging for them to hold down a job, that's being unable to participate in one of those activities due to a physical, or intellectual, or emotional condition. It doesn't need to be that that's forever true in order to satisfy these criteria. I also know that in some states, they've really broadly interpreted provision C, the removing barriers to employment, to include things like seeking to re-enter foster care. So if you've had a child who has signed themselves out of care, wants to come back in, and maybe doesn't fall into any of the other criteria right now, just the fact that they're saying, hey, look, I need more supports right now, I'm trying to get back in the foster care system, that can be enough to be able to say they're trying to reduce barriers to employment, and they do meet the criteria.
And just to kind of piggyback on that point, Title IV-E and the regulations interpreting it really lends support for the idea that all of these categories should be interpreted broadly. These provisions are all categories of youth who are funded by Title IV-E if they remain in care, and the federal law really encourages that these laws should be used to cast a wide net to increase eligibility, and really every youth who can stay in care until 21 should be allowed to stay in care. So there are arguments that any of these can be interpreted broadly. And also just one more key component is that Florida allows youth who have exited care after 18 to return to care before age 21. So in terms of transition planning, it just kind of shows us that it's really important to come up with a plan B for youth. A youth who is 18 might be sick of the system and be ready to get out, and then on their own might realize that there are supports that they could benefit from. So leaving an open door, or at the very least, helping them come up with a plan to be achieving one of these categories if they decide they need extra support, and a plan for who to contact and how to come back into the system can be very important.
Absolutely. So this sort of final transition planning slide is designed to illustrate both the fact of there being so many service systems involved as a young person with a disability is entering the adult serving systems, and also really show what a cliff our young people are encountering as they're about to age out of care. So there's the sort of healthcare transition literature. So this is research focused on young people with special needs, not necessarily in the child welfare system. Describe when you hit 21 and the EPSDT guarantee goes away, and when you also lose access to special education services that also only go up until age 21, that's the equivalent of falling off of a social services cliff. That there's all sorts of young people who have been getting sort of robust both healthcare and educational and employment-related services through EPSDT or through the school district, and then at 21, suddenly they lose access to those things. And planning for that moment is an area of research in healthcare and in disability rights advocacy. Now, our clients, or the young people that we work with, they're also encountering the loss of child welfare support at that point. They're facing both the healthcare cliff and the child welfare cliff. And so it can be obviously a really, really critical period and one that poses a really high risk to kids. But this slide is trying to be less downer than that and focus instead on the fact that there are some things available, obviously, after you age out of care as well. And so a couple that I want to highlight. A 504 plan, this is a little bit different than an IEP in several important respects, but it's another mechanism for getting educational accommodations for individuals with disabilities. And so if you have a client who's entering a post-secondary program and so is not going to be able to have an IEP anymore, but did have an IEP while they were in high school, they could get a 504 plan to have similar types of accommodations provided in the post-secondary setting. Now, they have to ask for it affirmatively, they have to provide the documentation of what their disability is and why they need that. So it's something that they can't just expect the college to come and ask about, but it can provide similar supports. Vocational rehabilitation is another service system. It's a federally mandated, every state has an Office of Vocational Rehabilitation or something else that might not be called that, but provides those services for individuals with disabilities to provide employment supports, and that can begin at age 14 and there's no upper age limit. So it's something that can both provide continuity and services for individuals with disabilities beyond age 21. SSI, this is the benefit administered by the Social Security Administration for low-income individuals with disabilities. That also has no upper age limit. And so it's something, you do have to have a redetermination at age 18. There's a different eligibility standard for under 18 and for over 18, but it's something that's available to adults. And then the Chafee education and training grants continue beyond time and care, and now Medicaid for former foster youth until age 26, which hopefully will be surviving as time progresses here, is something that's continues beyond time and care. So with that, I think we're relatively on track, almost. We are going to do an advocacy activity. So this is designed to get us thinking about these concepts in the context of some specific cases. And Lisa's going to be handing out, we're doing two. The two halves of the room? Yeah. Well, there's a lot more people on this side. Maybe do the front 3 rows and that half and then the back. Is that okay? Yeah. So in groups of about 3, we thought, right? 3 or 4? 3 to 4. Yeah. So you'll have to talk to each other and sort of stay awake here at the end of the day. We're gonna be giving you, everybody will get a copy of one of 2 factual scenarios. These are real cases, I'll tell you. I mean, some of the facts have been slightly changed, but they are individuals that we worked with. Who are encountering various transition-related difficulties. And so you've been given some background and also a scenario. And I'll give, spoiler alert, the scenarios all are you preparing for a court hearing for various reasons. And so what we're asking you to do is spend a few minutes reading over it. And I'd like you to actually have somebody in your group read it aloud so you're all sort of hearing it and thinking about it for a second. It's a lot of text otherwise. And then you're going to be asking yourselves sort of 3 questions. These are also on your handout. But what steps or actions would you, if you were the child advocate, want to take before the hearing? Are there things you want to try to get lined up? Are there meetings you'd want to have? Are there actions that just are so urgent that you couldn't wait for the court hearing, or just things that would set you up better for the court hearing? And then how will you counsel your client in advance of the hearing? What questions are you going to ask your client? If you have someone that's thinking about signing themselves out of care, what might your response to that be? So think about sort of what questions you'd ask, what ideas you have for talking to your client, and then all leading up to what are your primary arguments going to be at the hearing. There's probably, we don't have time probably for you to cover everything that you might want to address at the hearing, but think about what the big things are and maybe what the secondary ones are if you have a moment. You don't have to articulate, here's the legal provision that I would cite to, or here's exactly how I would make it, but sort of try to issue spot and tie it, and if, to the degree that makes sense to you, think about it in terms of the legal rights that we just covered. So this is the big picture of all the information that Lisa and I just sort of bombarded you with. The right to screening, assessment, and treatment. Could that help with something that you'd like to see done for your client? Appropriate placement, permanency, developmentally appropriate activities, high quality education, or transition planning. So think of your legal hooks and think about the scenario. And we've given you a worksheet that we'd like you to fill out as a group about sort of what your next steps are, what your questions would be. So we're gonna spend about 15 minutes in your groups reading over it, talking it through, and filling out the chart. And then we're gonna ask for one representative from each of the fact patterns to sort of report out what your next steps were. So just be thinking about whether you'd like to do that. It's not no pressure or anything, but just we want to spend a moment as a group talking about what the ideas were. So we're gonna Lisa's passing it out now, and then we'll come back together at about a little after 3:15, 3:20 or so, and hear your report outs in the group. And we'll be circulating around if you guys have questions or anything like that. All right, so we're going to come back together, and what I'm going to do is I'm going to read out the background in the scenario because obviously you guys only heard one of the two, so that we can all be thinking about the same one for a moment, and then I'm going to ask some representative from a group for each of them to just sort of talk about what the major themes were. You don't have to do it by walking through what you put on the chart, but you certainly can, and we can kind of then hear, other groups can chime in if there's other things that people talked about that aren't what the first person brought up. But we'll spend about 5 minutes on each of them. So first, we're going to talk about Jonathan. And I'm just going to read the whole thing so that everybody has the same scenario in mind. So Jonathan, who's 19, has been in the foster care system since he was 7. He has type 1 diabetes and a long history of mental health issues. For the last 6 months, he has been placed in a residential treatment program paid for through his health insurance. The program is expected to last roughly a year and is focused on providing intensive mental health supports. The program is also helping Jonathan learn to manage his diabetes on his own, something he's never done before. Jonathan feels he's been making progress in the program, but he'd like to be more independent. He has a close relationship with his former foster family, and the facility uses earning visits with them as an incentive for good behavior and progress in his treatment. Jonathan also has a new girlfriend in the community. He receives SSI, which is currently paid to the Child Welfare Agency to cover the cost of his care. He's debating signing himself out in order to gain more control over his life and finances, and he feels he can reasonably do this because his housing would remain stable for the next 6 months while he's still in the treatment program. He's currently in cyber school and is on track to graduate from high school this term. He's been admitted to the local community college in the fall. So you're his child advocate, and 2 weeks before his next permanency hearing, Jonathan earns a weekend home pass. He spends the weekend hanging out with his girlfriend and her friends and gets caught up in the social activities of the weekend and fails to monitor his insulin. He starts displaying symptoms of a blood sugar imbalance, but does not want to call his caseworker at the facility for fear of getting in trouble. He ends up having a hyperglycemic crisis and being admitted to the hospital. Jonathan's case manager revokes his home pass privileges indefinitely as punishment for the incident, and now Jonathan is increasingly angry at his lack of freedom. He also has been unable to visit his former foster family, which staff at the facility think has contributed to some setbacks in his mental health treatment. He is talking more seriously about signing himself out of care, and now threatens to leave the facility to go live with his foster family or his girlfriend. I should clarify that signing yourself out of care, this is possibly a Pennsylvania colloquialism. I'm not totally sure. This is referring to deciding to leave the child welfare system. So because he's 19 years old, he can decide he wants to exit foster care. So that's what we're meaning by signing himself out of care, not just necessarily leaving the treatment program that he's in. In fact, he wants to stay in the treatment program. So is there a Jonathan representative who wants to talk about what you guys focused on? Yeah, thank you. And actually, this might be a time, do we have the roving mic in here, or can I? Okay, fabulous. Step one.
We kind of broke it down, and I'm going to be covering the steps or actions I would take before the upcoming hearing. I think the first step I'd want to do is contact the caseworker at the facility or contact their supervisor and discuss with them the importance of not using visitation as the tool for compliance. I think they could find some other way of other punishment system or other way of rewards or punishment other than visitation, because I think that's a very poor way of using it. Mm-hmm. I'm assuming that this is a new case to me, so the first thing I would be looking at is reviewing the evaluations that were made concerning his mental health records, because I want to know exactly what is his problem. I want to see what the treatment plan is for his mental health unit from the facility. I'd be reading the latest treatment team evaluations and conclusions. I'd also want to contact the foster parents, the former foster parents, and see if I could get them involved as part of a team to help help the youth, help Jonathan, and I'd be looking at the possibility of whether, it doesn't sound like he would need a guardian advocate, but he might need a surrogate for health, and somebody that, you know, maybe even a power of attorney, if I get the foster parents to sign in there, to be able to assist him with his health care decisions, because I'm going to be looking at, you know, what am I going to be wanting to do in the long term, and I'm going to be needing to find out before court what resources I will have so that I can advocate for that in court.
Great.
All right, and I'm doing the second bullet. I'm going to counsel him in advance of the hearing. You know, I looked at his mental health records, and I know he's likely to light up the judge in the courtroom, so I'm going to talk to him about that and not to start talking bad about the family care manager who's done him wrong. We're going to discuss those issues, and then we're going to get into the substance. In Florida, as you know, I mean, I'm going to try to talk him into staying in care. Yeah, at 19, but here he can stay until he's 22, and we're going to talk about the pros of that, and the additional monies and the additional assistance. And now that we've gotten the weekend pass thing taken care of, we got that, made that go away. Then we're going to talk about the cons of him leaving the system, opting out of the system. The flip side of that, I'm going to find out what his goals are. I don't know what his goals are. We're going to talk, that's going to be part of the counseling prior to the hearing. And I'm also going to want to review with him the Social Security aspects of it, the income. He may think that that's $1 million a month and that he's just going to be living like a king. We're going to discuss those issues all prior to the hearing.
And I have the third bullet point. A primary objective is going to be to put together a transition plan for when this residential program is over, whether that's a foster placement or some other independent living arrangement. We want to keep him local to the community so he can go to college in the fall. We want him to have the mental health care services that he needs set up for him in the community, and we want him to have the medical care he needs as well.
Great. Thank you so much. Does anybody else who had Jonathan want to add anything to that? Yes.
Well, we were just discussing the fact that he, since he's aging out of foster care, or still in extended foster care, he'll have his community college paid for, and that there's a possibility that he might need some accommodations while he's in school. And since he's got diabetes, that would be a qualifying element for a 504 plan.
Great.
In addition to the mental health.
Oh, thank you.
I don't want to scare you walking up behind you like that.
Thank you. I was just mentioning the possible necessity of a 504 plan since he's enrolling in post-secondary.
Great. Yeah. All right. I see another hand over here. Here. Let's see. Can we? Where we go?
We didn't think that the fact that he went off his diabetes management, that should even be a punishable action. That maybe set up an appointment with his doctor, go in and use it as an educational to really stress the importance of managing your diabetes because it could be life-threatening. Also, no one mentioned the girlfriend yet. I'd want to know, you know, without being too overbearing about it, want to find out who is the girlfriend, how old is she, what is her housing situation. He's in residential treatment, presumably because of maybe substance abuse. Yeah, it wasn't really clear why he was in there.
Right.
You know, what is her situation and how might that relationship bring any new risks into his situation?
Good. Yeah.
Hold on a second.
Nope.
The thing that was concerning to me was the whole approach, because I agree with what she said about the punishment, but I would add that the emphasis was not on making him independent. The emphasis was on making him permanently dependent. And that's the problem I had with the plan. He's a young man. He's going to make some mistakes. The fact that it was near life-threatening should not have been a surprise to anyone. That is why you let him go out, so you can see the mistakes. You want to see the mistakes while he's in treatment, because when he goes out on his own, then he won't have anybody to correct them. And I'm going to end it like this. I think when we have people in treatment and they're becoming young adults, it's imperative that what we try to aim at is teaching them the skills to be independent, not punish them in a way that makes them permanently dependent.
Thank you. All right, that's a great conclusion. Yeah. I want to give Monique people just a moment. I know we're about to be running short on time, or probably are already. We're at 3:29. But if people would bear with us for just a second to give a little bit of discussion to Monique. I won't read, sorry, we had one we couldn't even get to. But I won't read the whole scenario for her. But you can see the summary up here. She's a young woman, 18 years old, who has spinal muscular atrophy, which means is a severe physical handicap in that she requires a wheelchair, sometimes has seizures and needs a ventilator at night. But she has no cognitive or developmental limitations. She was with her grandmother, but when her grandmother passed away, she's been bouncing around from institutional placements. And unfortunately, she's now in this wildly inappropriate placement for adults with serious developmental limitations, most of whom are nonverbal. And she has none of those needs in common, and so she's very unhappy, is wanting to return to the community, and is also talking about signing herself out just because of how unhappy she is at this point. So this is one that you've just inherited this case, unfortunately. I see a volunteer ready to go, so let's hear what you were going to do for Monique.
We are ready to go. This is the team of Ken, Jessica, Monica, Monique, Monica, and Larry. And the first thing we're going to, look at that child. What a beautiful child. Look at that. What she needs right beside her is a seizure dog. And put her in a county that will allow that seizure dog to go into that school with her as she continues her schooling. That's the first thing we think. That would complete that picture. There are 6 areas that we covered. Placement, she's in the wrong place. She needs to be moved to a more appropriate, age-appropriate, and developmentally appropriate placement. She's in the wrong place. 2, education. Can she get education? Yes, the Chafee grants, the state grant program is available to her because of her status. Also, she could do distance learning. We might find her an internship someplace. The next thing was support systems. We're going to get Eva Carbone from, Martin County, to be out there looking for some other relatives of Monique beyond the grandmother. Funding, we need to be looking at SSI. We need to be looking at continued Medicaid funding because she can get it until she's age 26. There may be other funding sources that we can find as well. She's got medical issues, obviously. We need some medical assistance. She's going to discharge herself AMA, and we don't want her to do that. So we need to counsel that. Finally, employment. We think we can get computers for her. She wants to be a journalist. We can find her an internship. The dog in the internship, she's on her way.
All right, well, that's a wonderful positive note to end on. I'm sorry that we didn't get a chance to have more input on Monique, but I don't want to keep you guys late on your last session of the conference. So thank you so much for your attention. We do have some summary slides that were kind of the big picture takeaways. Feel free to review those on your own time, and also some cases that are real places where people have advocated for this in court. So,
And just really quick, you'll see at the very end highlights from the field in your conference materials as well, so on the app, and then once they're on the website, they'll be there too. We have more in-depth discussions of the cases that we relied on in creating this presentation, so feel free to check those out also. Thanks.